So welcome everyone to Sheppard's webinar. Please note that this webinar is being recorded and the materials will be circulated after the program. If you have questions during the presentation, please use the Q&A button at the bottom of your screen to submit a question. We'll do our best to address questions throughout the presentation, but if you do not get your question answered, please feel free to reach out to one of us after today's program. We're going to start with introductions. My name is Geraldine Cardoso. I am a partner in the Del Mar, San Diego office for Sheppard. I am one of the corporate practice group leaders for the firm, and my practice primarily focuses on healthcare M&A, representing both sellers and buyers, including private equity, across the United States of all sizes. John?
Hey everyone, John Golomeski. I'm a partner in the downtown San Diego office of Sheppard. I focus primarily on representing medical groups and other professional entities and work a lot on corporate formation, governance, operational compliance for healthcare companies, and I also do a fair bit of merger and acquisition work as well.
I'm Lenny Lipsky. I'm a partner in Sheppard's New York office. I advise healthcare companies as well as investors in healthcare companies on health regulatory matters, operational compliance, and investment structuring. Sheppard's healthcare team is one of the largest in the country with over 250 healthcare attorneys. Law 360 has named our healthcare practice group of the year 5 times, including most recently last year. And our healthcare team is supported by a resource of a full service firm of more than 1,200 attorneys nationwide.
Great. Well, welcome again, everyone, to part 1 of this 2-part series where we will be discussing key legal considerations for MedSpa operators. Today, we'll largely focus on corporate and operational considerations for starting and owning a MedSpa. And at the end, we'll provide some brief insights into current market trends and highlight a few things that buyers or investors may focus on in an M&A transaction. Part 2 of this webinar series will take place on Tuesday, July 28th, and will focus on the regulatory and compliance aspects of owning and operating a MedSpa. If you have not registered for part 2, there's still time. With that, we'll get started with today's presentation. The first thing we want to address is, what is a MedSpa? A MedSpa is really just a marketing term, and whether the business holds itself out as a MedSpa, a wellness center, or something else, we really need to look at the services being provided to determine the proper structure of the business and what rules and regulations govern the business. So with that in mind, the first threshold question that any owner or operator of a MedSpa must ask is whether or not the business is practicing medicine. Depending on the services being provided, the answer might be yes. If the service requires clinical judgment, prescription authority, professional delegation, or management of patient risk, it's likely deemed a medical service, which would put the business within the scope of practicing medicine. Now, this does vary by state, and you'll hear throughout today's presentation and the part 2 presentation that a lot of what governs the business and operations of a MedSpa is state specific. So depending on where your operations are located, you'll need to consult with counsel that is familiar with the state laws to determine whether or not you're practicing medicine within that state, or whether any of the other rules and regulations that we'll talk about today and that the team will talk about in part 2 apply. But a good rule of thumb when you're thinking about whether or not you're within the scope of practicing medicine is whether or not any of the services that you offer have penetrating the skin, such as Botox or fillers, whether you're providing delivery of any energy type services, whether that's lasers, radio frequency, IPLs, or whether or not you are prescribing drugs, including hormones or GLP-1s. In each of these cases, you're likely deemed to be providing medical services and will be within the scope of practicing medicine. So if a MedSpa provides any of these services and they're within the scope of practicing medicine, what does that really mean, Lenny?
So in most states, in 2/3 of the states, there is something referred to as the corporate practice of medicine prohibition. At its core, it's a general prohibition on non-licensed individuals or entities owning, operating, or controlling medical practices. The root of these prohibitions is the concern that otherwise medical professionals' decision making will be driven or influenced by the desire to make a profit as opposed to patient care. And so 2/3 of the states have some sort of corporate practice of medicine prohibition, and then some states also have a corporate practice prohibition that might extend to nurse practitioners and certain other types of licensed professionals. Depending on the state, consequences for violating CPOM could potentially, and this is, by the way, both for professionals and non-professionals involved in such an arrangement, it could potentially include civil and criminal penalties, discipline by the applicable state licensing board, including loss of license, denial of reimbursement for professional services if there are payer contracts involved, invalidation of contracts or false claims or insurance fraud allegations. So there really is a host of potential penalties associated with violating CPOM. And challenges to CPOM compliance can often come from a variety of sources, including state medical boards, state attorneys general, patients, payers, employees, disgruntled professionals, or competitors. Of the 2/3 of the states that do have a corporate practice prohibition, some are more stringent than others and some have more active enforcement climates than others. There's also been a recent uptick in legislative activity, with certain states passing laws tightening their CPOM prohibitions. Oregon is an excellent example of that. California is an excellent example of that. So, for those following, Oregon recently, which always had a corporate practice of medicine doctrine restriction, recently codified it and extended it to restrict certain other activities. John can speak to California and what it's been doing on the CPOM front.
Yeah, California is considered one of the, I'd say, stricter CPOM states. And when you're thinking about CPOM and the practice of medicine, one of the things that means is that you need to have an entity that is permitted to practice medicine as the ultimate owner and provider of the service. And we'll talk in a little bit about the different structures that you see to sort of allow non-physician ownership and participation in a med spa business. But for now, we're focused on the entity that's providing the medical service. And so in states that have CPOM, that entity needs to be a professional entity. And so that's typically either a professional corporation. Some states have what's called a professional association, which is similar to a professional corporation, or a PLLC, which is a professional limited liability company. And so the key thing to keep in mind for any of those entities is who owns and controls the professional entity. That's generally got to be a physician. Now, in some states, California, for example, it does allow non-physician ownership of a professional corporation up to 49%. But in California, the 49% has to be owned by other licensed medical professionals. So nurse practitioners, physician assistants, registered nurses. Some states don't allow any non-physician ownership. Some states actually allow non-licensed ownership up to a certain percentage. So it really varies by state. That's, as Geraldine mentioned, that's going to be a common theme that you're going to hear is the state laws vary across the board. So that makes it a little bit more challenging to operate a med spa business, especially if you're operating in multiple states. Some states allow professional corporations formed in other states to practice medicine in a different state. Some states don't allow that. So that's something else that if you're operating in multiple states, you need to really make sure you understand whether you need maybe multiple professional entities, for example, one in each state, or whether you can use a single entity across multiple states. Some states don't have CPOM. Florida is an example of one state that is a non-CPOM state. And so there you don't need to have that physician ownership of the entity, but you still need to make sure that you have a physician who's controlling the clinical decisions. And there are lots of other rules that will apply even in a non-CPOM state. So for example, you may need a clinical license if your entity isn't a professional entity. So even in non-CPOM states, it can sometimes make sense to operate the clinical side of the business through a professional entity.
Great.
And there's also, some states also have an active practice requirement. And why that's important is because, we're talking about physician ownership of the practice, but then there's also not to be confused with who your medical director is when it comes, in a med spa. Oftentimes it's the same person, but in case it isn't, the medical director, given the scope of the services that the medical director provides, will ultimately always be providing medical services within the meaning of that state's, practice of medicine statute. And so even though you can have in certain states a physician who's licensed in a different jurisdiction being the shareholder of the professional entity, you will always require, and we'll talk about medical directors a little later on in this webinar, but you'll always require, it will always be the case that the medical director has to be licensed in the state in which the services are being provided, because it will be essentially capturing the practice of medicine.
Great. So let's talk about the entity structure a little bit. So Lenny, we talked about CPOM states, non-CPOM states. What does that structure look like?
So, the typical way that sorry, which slide are we on? They disappeared on my screen. Is this
The entity structure. Yep.
entity structure. So, many states recognize a professional entity structure, whether it's CPOM states or non-CPOM states. They all allow professionals such as physicians to come together, form a professional entity. So a PC or PLC, which I'm sure many of you have heard about before. In some states, they're PAs. In corporate practice of medicine states, those are the types of entities that would be required for providing medical services: a professional corporation, a professional LLC, or a professional association. And generally most states have PCs and PLCs, but that's not always the case. Some states recognize PAs, professional associations, and not PCs. Some states recognize LLCs, but as long as they're comprised of licensed physicians, it's as if it's a PLLC. And then even in non-CPOM states, generally you don't need a PC or any other kind of professional entity to operate a med spa. But to John's earlier point, depending on if you're operating across states and generally the size and scope of your operations, you may want to use a professional entity. And then so there are some state-specific rules. So really looking at where your operations are today, where you expect them to be tomorrow, is really key, because unfortunately there are 50 different sets of rules when it comes to these things.
Yep.
And just, briefly, there are tax implications whenever you're selecting the type of entity that you're going to use to operate the business. And I'll keep it at a high level because obviously when it comes to tax, the devil's in the details. But at a high level, there are really two types of entities. There are pass-through entities, which LLC is generally a pass-through entity. Although to complicate matters, it can elect to be treated as a non-pass-through entity, but let's kind of ignore that for now. And then S corporations, which you've probably heard of, are the other main type of pass-through entity. The main differences between an S corp and an LLC: in an S corp, if the owners are providing services to the business, they have to take a reasonable salary or reasonable compensation out of the business before they distribute money as profit. And what that means, practically speaking, is that you're going to have employment taxes, Medicare, Social Security, the withholding, at least a portion of the money that you pull out of the business if you're an owner operator of an S corp. LLCs, you don't necessarily have that requirement, so you can sort of pass through all of the income directly to the owners, but you may have self-employment taxes. So these decisions, which one makes sense for a particular scenario, it's really best to work with your CPA, because your individual circumstances may dictate whether one is better than the other. The other type of entity is a non-pass-through entity, and a C corp is what you'll typically hear for a non-pass-through entity. The main feature of a C corp is that it's the entity itself pays taxes. So any income or profit that the C corp has, they'll pay tax. The C corp itself will pay tax. And then to get money out of the C corp, you either need to do that through compensation, which will be subject to employment taxes, or as dividends, which are also taxable to shareholders. So generally speaking, C corp is usually not the most tax efficient vehicle. And we'll get to this in a later slide. It's sometimes in ours, when talking about med spas, it can sometimes make sense to have a C corp for your professional entity if you don't want any income to pass through to the owner of that professional entity. And the next slide kind of gets into maybe why that would be.
Yeah. And so why don't we talk about the next slide, which is really around ownership alternatives to ensure that you can have an investor that maybe isn't a physician.
Yeah, so this is, and you'll hear different terminology, MSO model, you may hear friendly physician model or friendly PC model. They're all really the same thing, but this is really the way that non-physician owners and non-licensed professionals can operate med spas and can receive the economic benefit of owning a med spa. At a high level, you have essentially two entities. You have the professional entity, which we've been talking about, and that's the entity that actually provides the clinical services. It employs the licensed professionals. It owns the medical records. It's the one that's practicing medicine. And then you have on the other side the management services organization, MSO, which is providing all of the support services that the professional corporation needs. It's providing administrative services, it's providing sort of business management services, maybe it's doing the billing. Usually it's going to hold the lease and provide that space to the practice entity. And there's an agreement between the professional entity and the MSO, where the MSO provides all of those services I just mentioned in exchange for a management fee. And the professional entity pays the management fee. So in this structure, generally, the professional revenue, the patients are billed under the name of the professional entity, and then they use that revenue to pay all of their expenses that sit within the PC or the PLC, and then they will pay, generally speaking, it's most, if not all, of whatever's left over to the management company. And that's where the goal is that the economics of the business really sit with the management company. And this is when we talk about when might you want a C Corp. Sometimes you want a C Corp for your professional entity because you don't want whoever owns that professional entity to have to pay income taxes on any income that the PC generates. So this is sort of the basic model. We'll talk about this a little bit more, but the idea here is that usually your professional entity is owned by, 1, 2, maybe 3, quote unquote, friendly physicians. And these are physicians that are generally tied contractually to the management entity, so that at the end of the day, it's really the management company that has the non-clinical control over the business and has the ability to, 1, generate or realize the profit, and 2, have some control so that you don't have a physician who decides to fire the management company and take the business for themselves. That's really the goal here. So there are ways through proper structuring to make sure that your management entity has the protections it needs, so that if you've got non-physician investors, their investment is very well protected, and they don't have to worry about losing the investment because they don't own the professional piece. So the important thing here, and I think we can go to the next slide, is when you're setting up this structure, it's really important to understand which entity is doing what. And so, as I mentioned, the equity of the professional entity has to be owned by generally a physician. A couple slides back, we talked about some scenarios where a non-physician can own, a minority interest in the professional entity. So, that's something that is potentially available depending on what state you're in. But the key idea here is that there's a physician that has ultimate control over the entity. And you really need to make sure that your practice entity is making all of the clinical decisions and owns the quote unquote clinical assets. And so, here, only the practice entity should be making hiring decisions when it comes to hiring licensed personnel or other physicians. And any clinical decisions need to be made by the practice entity. The MSO can be involved in sort of business decisions, non-clinical decisions, but it's really important that you try to keep as bright a line as possible between those two things, because that's where problems can arise. And even if you've got all the paperwork prepared correctly, it doesn't really matter if in operation you've got an MSO entity that's making decisions that are really clinical in nature. So the practice entity needs to employ the clinical staff and needs to make the clinical decisions. On the MSO side, generally speaking, you'll see the MSO owning all of the non-clinical assets, and that's usually everything from the equipment, the tables, the chairs, whatever you've got, you're in your medical practice. Usually the MSO will also be the party that has the lease for the property. And then it will hire and can hire non-licensed staff. So the non-professional staff can be hired by the MSO. And that's everything from your front desk people to your billing people. Sometimes nurses can be hired on the MSO side. Again, it sort of varies by state, but the idea is that the MSO is providing as much as it can provide, because the goal is that the MSO is justifying the management fee that it's receiving from the professional court, because it's providing a lot of services and staff and supplies to the PC. So this allows the MSO to really be the entity where the capital can be invested to basically build out your space, to provide working capital, to hire employees. And then the MSO ultimately recoups that investment through the management fee that it receives. And sometimes there's a structure where the MSO is effectively loaning money to the PC so the PC can get up and running. But that's really the structure that allows a non-licensed person to effectively operate a med spa, as long as they're not making clinical judgments and clinical decisions. And really, I think the key takeaway here is that you really need to make sure that in operation that you're following this sort of framework. And generally speaking, the way to do that is through things like your clinical workflows, supervision protocols. When you're deciding which equipment to buy, you want that to be a decision of the PC. So any decision that requires professional judgment really should involve your medical director. And so the way that you operationalize that typically is through your policies, procedures, workflows, and reporting structures. And if you keep those things pretty tight, then you can avoid a situation where the MSO starts to make clinical decisions. And that's really what regulators look at, is at the end of the day, they want to make sure that you don't have non-licensed people doing things or making decisions that really should be done by a licensed person.
Great. And so I think we talked a little bit, right, about that administrative services agreement. Lenny, you want to talk about sort of some of the key functions of that and what regulators might look at?
Yeah, and just one thing to add to John's point just now, the physician shareholder of the professional entity must really maintain an active and meaningful role in the operations and clinical oversight of the PC, because if these arrangements are ever scrutinized, that in addition to the key points that John just raised and what I'll bring up about the administrative services agreement, but the regulators and courts will look to see whether or not the physician shareholder is overseeing the clinical activities, overseeing the corporate formalities of the business, and really playing a meaningful role in the administration and operation of the PC. And of course, the physician shareholder can consult with the management company in making business and management decisions, but ultimately it's the physician shareholder who's responsible for maintaining those corporate formalities and ensuring that the quality of clinical services at the PC are delivered appropriately. As far as the administrative services agreement goes, this is the main vehicle through which this relationship between the MSO and the PC works. Pursuant to this agreement, the MSO provides all the non-clinical administrative business support services necessary to run the MedSpa. And it does this in exchange for a fair market value fee that's paid by the medical practice. The fee has to be set in advance, can't be adjusted retroactively, so you can't see how things went and then say, oh, well, let's adjust it. We meant this, for the last year. This is both for anti-kickback purposes, for fee splitting purposes, and generally for CPOM compliance. That's just something that can't be done. Now, the kind of fee structure that you could use will ultimately vary by state rules. Some states actually prohibit percentage-based arrangements. Some say that you can, percentage of, that the fee would be a percentage of the practice's revenues, for example. So some states allow percentage of gross revenues. Some states prohibit percentage of all kind of revenues or profits. You can structure it as a fixed fee, X amount, X dollars per month or X dollars per year. Or you can do something like a cost plus, like here the cost of the management company providing these management services plus a 10 or 20% markup, or or what have you. But in that case, it's that markup that needs to be fair market value. And then some, again, depending on the jurisdiction, depending on, certain situations, you might be able to utilize a discretionary bonus or a formula-based bonus. But there are some sensitivities surrounding that and whether or not that bonus could ultimately be viewed as a percentage of revenue. So if you're bonusing out, if you have a bonus every single year that pulls out the rest of the money from the practice and it's not justifiable, for example, well, then a regulator could look at it and say, well, isn't this just effectively 100% of profits? And so there's a lot of nuance to this. We actually work with a lot of fair market value consultants, national consultants, to help clients figure out how best to structure an arrangement like that. Importantly, the practice's assets are used to secure any unpaid obligations that arise under the administrative services agreement. And so if the practice fails to pay amounts that are due, in a worst case scenario, the MSO can go after the assets of the practice. As we'll talk about a little bit later on, med spas do tend to be equipment heavy. So unlike some medical practices, which are not, like primary care, for example, there are some assets that can be used to satisfy unpaid obligations. The typical term of an administrative services agreement, it varies. They're long-term agreements, so 10 years is usually the minimum that we see. Again, every state varies as far as their acceptance of like the length of an administrative services agreement or management agreement. By the way, they also go by that name. But 10 years, 15 years, that tends to be a nice sweet spot. The key risk is, and John mentioned this before, but if the services agreement gives the MSO too much control over clinical operations, staffing decisions, hours, treatment protocols, regulators may pierce that structure. And so, I like to say that a lot of it is art over science, because this is a doctrine that not only has developed over time, it's developed inconsistently from state to state. And so one of the things that we do, of course, is we use best practices from, one jurisdiction, apply it to another, and different companies have different risk tolerances as well when it comes to these things.
Yeah, and just to point out, so when we're talking about the term of this administrative services agreement and the fees, we're really talking about it in the context of what John was talking about, the sort of friendly PC MSO structure. If you have a med spa and you have an administrative services agreement with a third party that is not closely tied to you, it won't have as long of a term. You will have termination provisions that allow you to get out, and the fees structure will be different. So what we're talking about here is really when you have that MSO PC close-knit relationship versus a third party who might be coming in and helping you with some of your administrative and support. That's sort of separate and apart from your arrangement.
And I think it's also important to note that, what's sort of the reasoning behind this administrative services agreement? Well, even though there are rules, state-specific rules in many states about fee splitting, that professionals can't split fees with non-professionals, or medical practices can't split fees with non-professionals. You can always hire, or engage a vendor to provide you with certain services. And that's the concept here, that this is a turnkey vendor. Essentially the MSO is providing all of the non-clinical services in exchange for a fair market value fee. And so it's really important that not only that it be structured properly, but that actually in practice, reflects what's in the agreement.
And speaking of agreements, what are some of the agreements that we should be considering if we are operating a med spa?
So there are a lot, and their use will depend on what state you're in. If you're not in a CPOM state, at the very least, you'll be looking at this first cohort of documents, your certificate of incorporation or articles of organization that form your legal entity. Then depending on the legal entity, if you're a corporation, you'll have bylaws. If you're an an LLC, you'll have an operating agreement, maybe a partnership agreement, buy-sell agreement. You might have share certificates or stock powers. So these are like your real basic corporate documents for structuring a business. Subscription agreement, how do you actually become the owner of the equity in a business? Some organizational written consents. Again, this is how do you adopt all of these documents? And then importantly, the medical director agreement, which is essentially either an employment or independent contractor agreement for the professional and supervisory services that are provided by the physician. So if you're in a non-CPOM state, it's a bit more straightforward. That one legal entity most likely can carry out all of that under one roof. If you are in a CPOM state, you're going to need these additional documents, that relate to the structure that we've been discussing. So the administrative services agreement we talked about, there's this deficit funding loan agreement. So what that's used for is if you think about like if you had one legal entity in one business and you wanted to contribute money to that business to fund growth, for example, to buy equipment. Well, you could just make that capital contribution into that entity as the shareholder or equity holder of that entity, and then use that money. That entity uses that money to pay those expenses. If people are investing into an MSO, the MSO can't just give that money over to the PC for the PC to buy, for example, some clinical equipment that, maybe under state law requires to be owned by the PC. And that's not always the case, but it may vary. Or if the PC needs to hire more staff and there's not enough funding for that. So what happens is the MSO can lend money to the PC under this deficit funding loan agreement. And it's like a typical, loan and security agreement. It's secured by assets, provides for interest payments and the like. Then and this is an important one, the concept of a continuity planning agreement, or sometimes referred to as succession agreement or a directed stock transfer agreement. And this document is basically entered into with the physician, shareholder of the practice, and the MSO, and oftentimes the PC itself. It's either a 2 or 3 party agreement, and it provides that under certain circumstances, certain triggering events, if something were to happen, including with respect to the physician shareholder, like death, disability, or other triggering events, the MSO can appoint another physician to in turn appoint a successor owner to the PC. And that in large part protects the practice from a continuity of care perspective. If, God forbid, something happens to the physician, we don't want these patients not to have proper oversight. And then the last 2 documents are a consulting services agreement for the physician to provide certain services to the MSO. Not to get too much into the weeds on it, that agreement also does relate to the continuity planning agreement. If that agreement terminates, that is typically a trigger for a termination and a replacement under the continuity planning agreement. But conceptually, the idea is that the physician shareholder is also providing strategic guidance to the MSO platform as a platform on expansion, on business practices and the like, because it's not black and white. It's not just business services and clinical services. There's a lot of overlap. So it's important that the MSO really understands, and the MSO's leadership really understands that as well. And then the last thing is employment or independent contractor agreements for professional services. So, and this would actually apply in both CPOM and non-CPOM states. You need that, if you're hiring physicians, nurse practitioners, licensed practice nurses, estheticians, you typically need some sort of offer letter, employment agreement, or something that describes their responsibilities, how much they're paid, what their expectations are, maybe some non-compete, provisions, non-solicitation provisions. And so, it'll vary by state and situation. But that is the suite of governing documents that we would typically expect.
Great. And just to clarify, on the continuity planning agreement or succession agreement, we keep saying it, but that is very much dependent on the state as well in terms of what can go in there and what that looks like. So, and there has been some scrutiny around those arrangements. So just making sure that as you are setting it up, or even if you're already set up today, in this fashion, that you are making sure that you are up to date on not only what the statutory requirements are, but maybe what the legislature is doing as well. And I think that part 2 will have a bit more insight into that as well. We've talked a little bit about it, but the medical director, John is not just somebody whose name's on paper. And I know that part 2 in July is going to go much deeper into this, but maybe just give a quick overview about the medical director.
Yeah, we'll touch on it here, but really, and this is the key takeaway, is that your medical director isn't just the figurehead, right? They should be actively participating in the business on really any clinical decision or clinical protocols. I'll just tick through these quickly, but you want your medical director to have experience in the types of services that are being offered. It doesn't necessarily mean they need to be a dermatologist per se, but if they're a neurosurgeon and don't know what Botox is, that probably not the best. So again, sort of a threshold question is your medical director a physician who has some experience in the types of services you're offering? Protocols is really important. I mean, at the end of the day, where MedSpas get in trouble when regulators start asking questions is where there's a lack of documentation, and secondly, a lack of following that documentation. If you've got great policies, procedures, workflows, but they're sitting on a shelf and they're not really being followed, that's not good. So you need to have both pieces. You need to have your protocols in place, again, developed with your medical director, collaboratively and ultimately approved by the medical director. And then you need to operationalize those. Supervision, again, really important. Some services require physician supervision, and there are different levels of supervision. And again, part 2 will get more into the details. But your medical director needs to be actively involved. If somebody starts asking your staff at the MedSpa, if they know the medical director, if they've ever met the medical director, or last time they saw the medical director, and they say, no, I haven't met him, or yeah, I think maybe I know who that is, it's probably not a great answer. So again, you want your medical director to be involved in the business, at least when it comes to the clinical aspects. Director should be reviewing charts, should be making sure that the actual hands-on people who are providing the services are doing it correctly. There should be adverse reporting protocols, and the medical director should be available when there are questions or things that need to be escalated. And this is important for the MedSpa, but it's also important for the medical director, because at the end of the day, the medical director is really putting their license on the line. I mean, they are taking personal responsibility for any professional service that happens in that medical practice. So it's important for the medical director as well to make sure that they're involved enough in the business that they can be comfortable that things are being done appropriately. But again, I think that's probably enough for medical director for this part, and then part 2 we'll get into a little bit more detail on some of these things.
Great.
So it's important for medical directors.
Thanks. So we've kind of gone through structuring a MedSpa, some things you need to consider. Now we're going to turn a little bit to operational considerations. And one of the first things that anybody has in any business, right, is how am I going to make money, and how am I spending money and ensuring that the money I'm spending is actually giving me the returns that I want. Usually in a MedSpa business, it's cash pay model. There's not necessarily insurance. In some cases, there might be, but overall, it's a cash pay model. And a lot of people feel that if we are doing cash pay, there's no insurance involved, no government involved, then they're free from regulation. And that's just not quite true. Now, a lot of the things that are on this slide, part 2 is going to cover in more detail, but just wanted to highlight a few things. If you're thinking about a membership model, or you have a membership model or a subscription model, or a prepayment, so I pay you money and I get 10, sessions on the books, and I can use them at a certain period of time. There are 20 plus states that have rules and regulations around what that contract looks like when you take prepaid service for any of these medical services. And so you want to ensure that if you do have a membership model or a subscription model or prepayment model, that you are adhering to those requirements if the state that you're operating in has those rules and regulations. Additionally, one of the things that a MedSpa is going to be looking for is customers, right? They want to bring in more customers, and they are going to look at advertising, marketing. You may be looking at referral bonuses or paying incentives to influencers on social media, All of those things could have implications under state rules and regulations. And so you want to make sure that each of those arrangements that you have in place are within the confines of the legal requirements. For example, a lot of state medical boards have rules prohibiting misleading or unprofessional promotions. There is rules and regulations around before and after photos that you might have on your website or social media. And then there are regulations around how you can pay and the structure you can pay some of your third-party vendors, including influencers. So these are just areas to be mindful of as you're setting up your business or operating a med spa to ensure that you're in compliance with the rules and regulations that might apply. We're going to quickly turn. We've talked about a little bit about things you should consider when you are looking to drive revenue. But there are some costs obviously associated with operating a med spa. And one of the costs includes the inventory. So John, you want to talk a little bit about inventory?
Yeah, so primarily here what we're focusing on is the drug inventory, since that's probably your biggest inventory cost. And this is an area where you need to be careful because each state has specific rules about who can purchase and store and dispense drugs. And so it does vary quite a bit from state to state. I would say that the general rule is that the drugs, anything that require a prescription, should be purchased by the practice entity and paid for by the practice entity. Although, the way that the MSO structure works, ultimately those costs are borne by the business as a whole. And there are usually rules about how those drugs can be stored, who can possess them. Usually you want the drugs to be maintained by the practice and held in possession of the practice. So they're essentially assets on the medical practice's books. There are usually storage requirements in terms of who has access to the drugs. Some drugs need to be refrigerated, and so there are refrigeration requirements. And then inventory controls is always an important one, right? You've got to make sure that you are limiting access to the drugs to the people who are permitted to access them, and that you have a way to track that. And that's important as well. Dispensing, again, different states have different dispensing rules. Most states allow medical practices to dispense drugs to patients in the office. Some states have different rules about whether you can provide drugs in your office for somebody to take home with them other than samples. So again, it's very state law dependent. But the key takeaway here really is, make sure that, again, in pretty much every state, and non-CPOM states differ, but even non-CPOM states are going to have many of the same rules when it comes to storage and the ability to dispense drugs. But it's important to make sure that you've got good protocols and operation in place to make sure that you're have security over your drugs and that you're dispensing them appropriately. And as a general rule, it's really your licensed people who are going to be permitted to access and dispense the drugs, and non-licensed folks generally should not have keys to the area where you're storing those drugs. So again, it varies quite a bit by state, but generally speaking, you want whatever entity is the professional entity, or in the case of a non-CPOM state, under the direction of your physician, to be managing your drug inventory.
All right. Well, most of med spas obviously have people who come in person. And so one of the big issues that we also need to focus on with respect to owning and operating a med spa is leases. So John, you want to talk a little bit about some things to consider when you are trying to find a space?
Yeah, leases, this is an area that I don't think always gets the amount of attention it deserves. I mean, for the most part, this is probably going to be one of your biggest expenses after payroll costs. Landlords often have leases that are very favorable to them. And if you don't review your lease carefully, sometimes you can get into a situation where you might be responsible financially for certain things, or you may be stuck in a situation that doesn't work for you. And just a few areas that we've seen folks have issues. One, you need to make sure that your lease allows you to use the space for your intended use. And so oftentimes, as we mentioned, you generally want your MSO to be the tenant on the lease, because that helps justify the management fee, the fact that it's responsible for acquiring and managing the space. So generally speaking, you want your MSO to hold the space. MSO in a friendly PC model, at least, isn't the entity providing the service, but you need to make sure that your lease still permits the use of the space by for MedSpa and professional services. Some leases will say you can't provide professional services in this space, and that would be not consistent with your use as a MedSpa in most cases. So again, that's something that's important to pay attention to. Build out and maintenance. Medical space has different requirements for its physical plant than non-medical space. And so again, things like procedure rooms, you've got to have provide for your medical waste. Some equipment requires either it's different electrical requirements, or sometimes you need shielding for certain things. So again, these are all things to think about on the front end. And then a lot of times when it comes to tenant improvements and building out your space, you may need consent from the landlord. Sometimes landlords will contribute some portion of your cost. They make it back through your lease rate usually. But those are all things that you have to negotiate on the front end. You also need to think about permits and inspections. Some space is, maybe it's not zoned for a particular use. And so you need to make sure your space is properly zoned as well for how you want to use it. Assignment transfer provisions is interesting because the MSO is effectively providing the space to the practice. And so that's either done through a sublease, where the MSO is actually subleasing the space, or it's done through what's called a license to use the space. In either case, you usually are going to need consent from the landlord to allow anybody else other than the named tenant to use and occupy the space. So usually in your lease, you want to build in a clause that says, our affiliated medical practice is authorized to use the space as well. So you don't have to deal with landlord consent after your lease is already signed, in which case the landlord may be difficult or ask for concessions. Assignment is important often when it comes to an M&A transaction, and a lot of times we do a fair bit of M&A work, and having to get landlord consents in connection with a sale can sometimes be difficult. It gives a landlord quite a bit of leverage because they have the ability to slow down, if not block a deal, which you don't want your landlord to be in that position, because then they're going to very likely ask for additional concessions, higher rent, things like that. So ideally what you want in your lease is the ability to assign it in connection with the sale of a business. And usually there's going to be some level of approval, but you can build in terms that really make it a lot easier for you to assign the lease in the event of a sale transaction. So that's important to think about. HIPAA security matters. I mean, a lot of times, as a medical practice, you do have what's called PHI, protected health information. And so you need to take steps to protect that information. And so you want to have secure storage area for your medical records and usually your drugs as well. So that's something else to keep in mind when you're thinking about the build out of your space. The other issue that comes up frequently in leases are personal guarantees. So if you're a startup business or even a business that's been operating for a little bit, a lot of times the landlords don't want to just rely on the financials of the business itself. They want the individual owners to personally commit their assets in the event there's a breach of a lease. And so where that sometimes comes up in the friendly physician model is that sometimes landlords will say, well, it's really the medical practice that has all the revenue because it's providing the service that patients are paying for. So we want the owner of that business to personally guarantee the lease. And usually your friendly physician is, unless they're a significant owner of the MSO, probably doesn't make a lot of sense for the physician to do that. So sometimes you can get around that through educating the landlord. Sometimes you have to do, an indemnity with the physician to sort of indemnify them, but personal guarantees are always a little bit of a tricky issue, and it's just something you want to think about on the front end, how you're going to deal with personal guarantees and what that means if you have a friendly physician structure.
Even if you don't have a friendly physician structure, if you are just you have a PC and it's a startup, you may get a request for a personal guarantee as your revenues are being generated because you don't have any history. So that's something to be mindful of no matter what. Other things, as Lenny mentioned earlier, equipment is another area where there might be some expenses. So I know we're getting close on time. Lenny, want to just quickly talk about some options for equipment? You're on mute.
Thank you. Absolutely. Equipment in the med spa business could be very expensive, depending on the scope of services provided at a particular med spa. So it's important to weigh those options, whether to buy, finance, or lease. Equipment such as microdermabrasion machines, LED light therapy devices, radiofrequency machines, IPL devices, various body contouring machines, cooling devices. It really, some of them do have high upfront costs if you were to buy them. There are tax benefits from buying or financing over leasing. Oftentimes you can depreciate that equipment and it provides better tax benefits. But on the flip side, leases have, smaller upfront payments. You can still deduct them from, as operating expenses. But perhaps, that's not as high as depreciation expenses typically. So there are a lot of options to consider. We'll be circulating these slides afterwards, but, in the interest of time, just something to think about as far as, what you're looking for from a cash flow standpoint, from a tax standpoint. That's where, equipment financing, leasing, or buying really comes into play.
Great. Role of the employees. And I know part two is going to touch on this, but maybe just kind of walk through the various levels.
Yeah, absolutely. And this is, I think, from our experience when, with clients and just hearing about what's happening, what others are doing and where others maybe have some footfalls in the industry, the role of employees is key from a compliance standpoint. The physician obviously sits on top as far as being, having the widest scope of practice and the broadest authority when it comes to diagnosing, prescribing, supervising, um, providing medical services. Nurse practice, depending on the state, each state's going to vary in their rules, but oftentimes nurse practitioners and physician assistants have some sort of independent authority. Sometimes that requires physician supervision. There are rules on what does it mean to supervise. Do you have to be actively present on the physical location? Can you be present by Zoom or phone? Registered nurses typically have fewer things that they can do, but still clinical in nature, and so on down this list where you'll have licensed practical nurses, perhaps having even more narrow scope when it comes to the types of activities that they can perform, and estheticians, which tend to be purely cosmetic or non-medical services. And so it's important to understand who's providing what services in your med spa. And I've heard horror stories where it's estheticians providing services that only nurse practitioners should be providing, or something in between that. And that's where a lot of med spas and professionals can really get into trouble. So again, it varies based on each state's rules. Unfortunately, there are 50 different rules, and this has nothing to do with CPOM. It's 50 different sets of rules for what different types of professionals or non-professionals can do from a services standpoint.
Great, thank you. A couple other operational considerations. We're not going to go too deep into them right now, but just insurance requirements, making sure you have the appropriate insurance. Patient-facing communications. I think this will get a bit more airtime in part two, but ensuring that they are compliant with the regulatory rules and regulations. And of course, depending on your state, classification of the workforce and wage and hour requirements is going to be another area of focus, making sure, are they an employee or an independent contractor, and how do you classify them? How are you paying them, and whether or not that is in compliance with state wage and hour laws. And then licenses, there's going to be licenses at various areas. You heard Lenny talk about, the licenses or certifications you might need for your employee, depending on what you're doing. And then your med spa may need state licenses, or there may be local licenses just to operate the business generally. So those are some other key areas for you all to consider as you are owning and operating med spas. We're going to quickly turn to just investing in med spas in the last 5 minutes here. We did promise that we'd touch on a couple of market trends and some things that we are seeing in the market and things for you to consider if you are scaling your business or thinking about investing. So quickly, market overview here. This comes from one of our great relationships with an investment banking firm that is very focused in this space. But there are over 10,000 active med spas in the US. We actually think that it's quite a bit higher. We are seeing people enter the market daily. And this market continues to remain highly fragmented. They estimate that only about 10% are currently owned by private equity platforms or strategic players. So this is going to be an area where we anticipate there may be consolidation moving forward, especially as people are focused on wellness and health. Hormone replacement therapy, biostimulators, and peptides are some of the growth drivers that we're seeing and are very popular today, in addition to Botox and fillers, which have been around for a while. There are buyers out there that are in the market, but they are not as aggressive as they might have been in 2020 to 2024. They are more disciplined when they are doing their diligence. So it's important that if you are scaling your business and looking to eventually sell, that you make sure that your house is in order, that the things that we've been talking about are looked at and that you are in compliance so that when you go to market, the buyer will see that your operations are in order and pay a higher premium for that. But we are seeing a lot of buyers interested in this space. And if it is a high growth quality platform, they are paying high multiples. Some operational challenges that we are hearing in this industry around expansion. Underinvestment in digital marketing is one area, and ensuring that your marketing campaign is compliant, but also, that's where a lot of people are finding their med spas and where they want to get some of these services. Provider recruitment and retention. There are various states that have restrictions on non-competes. So ensuring that your providers are being retained and that you get quality providers is important. People often follow those employees if they're providing the services. They're very personal services. Talked about compliance structure, scheduling, and inventory management, making sure that you are buying enough of the drugs that you need, but also not too much that they expire and you can't use them. So that's a quick market overview and update. Just quickly, I'm going to go to the last slide here on pre-transaction readiness. If you are planning to go to market and looking to scale your business and potentially sell, some of the areas besides just looking at the dollars and the numbers is really the patient base and growth that a buyer is going to look at. Is there a loyal returning patient base? That's important because that's how the business gets revenue. We talked a little bit about workforce and provider stability, making sure that you are retaining those key revenue generating employees who may not be the individuals providing the actual medical services. It may be the front office staff, or it may be people that you've hired to help with marketing and advertisement, and making sure that those will stick around because a buyer wants those individuals to continue to be providing that growth. We've been talking today about some of the regulatory and compliance issues, and you'll hear more in the second part of the webinar. And then, as John mentioned, documented clinical protocols and operational playbooks so that you can repeat what that business is doing. And if somebody who was, is the medical director leaves for whatever reason, you have that documented policies and protocols so that you can continue to operate the business. And then reputation and brand, of course, is always important. And if you are using referral sources, making sure those relationships are compliant. So I know we are at time. I appreciate you all sticking with us. If there are any questions that you have following today's webinar, please feel free to reach out to any or all of us. I hope that you found this informative and we hope to see you on the part 2 webinar series in July. Thank you all.
Thank you.
Thanks for it. Right.